Good morning, and thank you for joining me on the Path to Liberty. It's Monday, July 6th, 2020. I hope you had an awesome Independence Day weekend and were able to enjoy a little time off. On this episode, though, we're back to talking about the police state and the doctrine of qualified immunity and how we can start the process of bringing it to an end without waiting on the federal government to police its own power. But first of all, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. You can find all of our archives, all of the episodes that we've done for the last 2+ years now, individual shows. I put links to specific articles, previous episode, a lot of stuff for you to read and learn more about. You can find all the platforms we're on, both live streaming video and archive video. Audio-only podcast edition, our social media channels, our email newsletter, and of course our membership program where you can support us financially for as little as $2 a month. And when a lot of people come together with just a few bucks here and there, we make it go a long, long way for the Constitution and liberty. You can find all that information and more over at the show homepage. That's 10thamendmentcenter.com/Path to Liberty, all spelled out. Again, 10thamendmentcenter.com/Path to Liberty. And before getting into all the details, it's some interesting stuff today. I think you'll enjoy this episode. I want to say hello to everyone out in the live chat, and I appreciate you whether you join me live or in the archive. I read through all the comments. I rarely get a chance to reply to all of them, but I get tons of ideas for future episodes, for follow-ups, for clarification. Sometimes people correct me on stuff that I've screwed up. So all that stuff is really, really good, and I appreciate it. Hello to Bob Landry out in Alamo City, Patricia Dance, Melody Skaman, Essential Freedom, MRGF 78, Justin Morrison, Heather Rossi, Tyler B, Pro-Life, Pro-Liberty, Benjamin Maddox, Felipe Fernandez, Blue Dragon 84, and Melody. Melody, you get 2 hellos. Awesome. So whether I missed you or not, I'm just kind of scrolling through and trying to dive right into this. I'm very grateful for you spending some time with me today. So let's get right to it. I want to talk about qualified immunity and hear from Jay Schweikert over at Cato, something that I've cited before. This is just a quick overview. Qualified immunity, is how Jay put it, is an atextual, ahistorical, judicial invention which shields public officials from liability even when they break the law. Qualified immunity means they are immune from lawsuit. Not all the time. It's qualified. So it's not the same as sovereign immunity, but in practice, it's pretty darn close. I covered this in a lot of detail, how it started. We can go all the way back to the 19th century and work through a bunch of Supreme Court cases and processes through the 1960s. And then, of course, the fallacy that is the incorporation doctrine, the judicial fiat that takes this bad precedent from the courts and then forces it on all 50 states. And here's how Mike Maharrey talks about it in an important article that we're going to be covering a little bit today. He says, typically, people sue police for using excessive force or other types of misconduct through the federal court system under the Bill of Rights, under the U.S. Bill of Rights, the Bill of Rights amended to the Constitution to the United States. But federal courts created a qualified immunity defense out of thin air, making it nearly impossible to hold law enforcement officers responsible for actions taken in the line of duty. So this is a judicial creation. And then because they've centralized control over the Bill of Rights, forcing it on the states, then they can implement their bad version of it on everybody. So the Fed's bad version of the Fourth Amendment, for example, now gets enforced everywhere. Mike goes on, he says, in order to move ahead with a lawsuit, the plaintiff must establish that it was, quote, clearly established that the officer's action was unconstitutional. And that clearly established test erects an almost insurmountable hurdle to those trying to prove excessive force or a violation of their rights. And I covered that in more detail again in this episode that I did last month, how federal courts gave us qualified immunity and then forced that view on all 50 states. So generally when people want to deal with a problem with law enforcement, they're like, well, I'm going to sue you in federal court. But the federal court believes their view reigns, and their view is bad, and their view means they've created a scenario that unless you can have the exact same situation, this is kind of a layperson's version of it, unless you have the exact same situation, the same scenario previously held by a court to have been an unconstitutional violation of someone's rights, they're going to say, well, it's not clearly established rules, so they're immune from lawsuits. So they basically, and this isn't just for cops, it's basically all government officials at all levels can get away with almost anything. This is how an empire acts. This is not a decentralized federal system under a constitution that protects individual liberty. Not even close. And you can see the Death Star that I've included here in the graphic for those of you watching for the previous episode back in June. I will include that in the show notes at 10thamendmentcenter.com/path to liberty. Now, hear from Ilya Somin, who does a lot of really good work for the Volokh conspiracy, which is published by Reason. This was on June 26th. He says, states can reform qualified immunity on their own. He says, unfortunately, the Supreme Court recently refused to take any cases that might overturn or limit the dubious doctrine it itself created. So what people generally do is they go to the federal government in the hopes that they can get part of the federal government to restrict what the federal government has done. And that in and of itself is a bad strategy. And it's even worse when what you're doing, what you're going to a federal court for, what you're trying to stop, get a federal court to stop, is something that the federal court created itself. The odds of that happening are almost zero, and we know just in late June that the Supreme Court turned down any opportunity to say, well, we had, these people who were here before us didn't do a good job, and we're not on board with this. And they just said no. They prefer precedent. They don't like changing the system unless it's expanding power and it's changing the Constitution. They don't like changing their own system. Somin goes a little further. He says Congress could potentially abolish or limit qualified immunity by adopting new legislation curbing it. And I know Justin Amash introduced some, maybe somebody else did, but I don't think Congress is going to do anything either. And I don't really want Congress to be having a say. I don't want the federal courts to have a say in how local law enforcement acts either. This is not a federal issue delegated to the federal government under the federal Constitution. And the reason being, and I'm not going to get into too much detail, is when you trust these people to do the right thing, who would go to the largest government, the largest empire in the history of the world to protect them from a local empire? This is just dumb strategy. Somin goes further. He says, but Senate Republicans say that such a move would be a poison pill, one of those types of legislation that would kill anything. They could put it on any bill, and that's just dead in the water. And it's not clear that GOP supporters of reform can gather enough votes to get it through this year. So in other words, if you go to the federal courts to restrict what the federal court has done, you're in trouble. If you go to the federal Congress to restrict what the federal courts are done and give them more power over everybody, you're in trouble. Nothing's going to change by going to Washington, D.C. to fix problems created by Washington, D.C. And I was thinking myself, like, there's not really much you can do about this other than hope it changes and bring a light to it. So I've been spending my time trying to shine a light on this issue, on the police abuse and the federal programs like civil asset forfeiture and the grant programs and the joint task forces that create a nationalized police force rather than a state or a local or decentralized one, as is supposed to be set up under the Constitution. But Ilya goes a little further. He says, in the meantime, there is much that state governments can do without waiting for federal action. Somebody beat the 10th Amendment to the punch on this because we hadn't even thought of this until something happened in Colorado. Ilya goes further. He says the vast majority of law enforcement operations, and this just makes sense, and law enforcement abuses are conducted by state and local police. State governments then can address their misdeeds without waiting for either the Supreme Court or Congress to act. He might as well be working for the TAC with that kind of message, because that's the kind of thing that I've been pushing out for so many years now. We're on our 15th year. We just started year 15. And the message is always, we need to learn how to exercise rights, whether the government wants us to or not. When enough people and enough states say no to what the federal government tries to force on us, there's not much the feds can do to force their so-called laws, regulations, or mandates, or judicial doctrines for that matter, down our throats. Going a little further, there's a law that was just passed in Colorado. Here, back to Jay Schweikert, another article from June 22nd. Colorado Governor Jared Polis has signed into law Senate Bill 217, otherwise known as the Law Enforcement Integrity and Accountability Act. It's a huge bill. Mike Meharry covered it, and I'm going to get to his report here again in just a moment. But basically, it ends the notion of straight up qualified immunity. And I know you're going to get some people arguing technically it doesn't really end it, but it creates a process that can actually change the approach on this. Going to the federal courts are not on anyone's side, so people spend a lot of time, money, and resources hoping that the federal court will take it up, and then the federal court just says, too bad, and then you're left with nothing. So you've spent time, money, sometimes years of activism to end up with no results, zero. But now Colorado has given us a model just last month of something that can make a change. It isn't a total, complete change, but it begins the process. Jay puts it this way: the law ensures that police officers in Colorado will not be able to avoid liability for misconduct due to the unlawful shield of qualified immunity. It basically specifically says in the legislation, qualified immunity is not a defense in state courts in Colorado. So if someone gets their rights violated or feel their rights are violated, then they can take up, and they don't have to go to the federal courts. They don't have to go to the federal government and say, federal government, come and protect me from these local law enforcement here, because that has just not worked. For decades, people have been doing that. And for decades, it has just been making things worse, because every time you go to the federal court, you're saying the federal government has final decision-making on this, and the decision-making has been horrible. And he's talking about Section 1983, and that's in federal law, and I will... you should actually check that out. I covered that in this other episode back in June. But he says Section 1983 creates a cause of action allowing individuals whose rights are violated under the federal Constitution. I like how he puts that in italics. He's highlighting federal Constitution to bring a lawsuit for damages in federal court. So basically, anytime someone has their rights violated, they said, well, this is a Fourth Amendment issue. I'm going to go to the federal court. The federal court applies the Fourth Amendment to the states, but they apply it in a way that the founders never drafted. They have twisted the original meaning of it, and then they give this broad grant of power or protection to government action rather than a protection to liberty, and then force it on everybody. So then people are suing in federal court, and every time they do that, it almost reinforces the bad precedent that's on the books because the Supreme Court doesn't take the side of the Constitution or liberty. So SB 217, which went into law already in Colorado, allows individuals whose rights are violated under the state constitution to bring a lawsuit for damages in state court. And in essence, you could say this really is an end to qualified immunity because there was no process to do this on a state level. And anytime someone thought their rights were violated, they just thought it was a federal issue and went to federal courts. And then the federal courts applied this system, which basically allows everyone everywhere in government to get away with violating your rights, stealing stuff. We know people have committed felonies working for government and gotten away with it because that's just part of the job. So this now creates a process in the state of Colorado where at least you can take it to court. That's no guarantee that you're going to win. That's no guarantee of anything. And in fact, some people might do frivolous lawsuits. Well, then they're going to have problems. So it isn't necessarily an automatic protection against the police state, but at least you have a chance to say, look, you have really gone overboard. Let's take this to court and see what happens. So, and that's what Jay basically says. The law does not technically eliminate qualified immunity insofar as we're talking about the federal doctrine. If Coloradans bring Section 1983 claims in federal court, those claims will still be subject to qualified immunity. But this is basically encouraging people to do what the Constitution is set up to do, to deal with issues of state and local government in state courts under the state constitution. Everyone thinks everything is a federal issue. And when you do that under the largest government in history, those federal issues are really going to be a problem for liberty. He says the law does ensure, at least with respect to police officers, that Coloradans will have a robust alternative remedy to Section 1983 federal claims for violations of their, and he says, constitutional rights. I'm just going to quick point out that I hate that phrase. No one has constitutional rights. People have rights. Colorado, he says, is not the first state to enact a state analog to Section 1983, but it is the first state to specifically negate the availability of qualified immunity as a defense through legislation. So this is the first state in history to ever say in state legislation, now law in Colorado, that you cannot, government officials, in this situation police, and I think it should cover all government officials, they are not immune from a civil suit for violating someone's rights if it can be proven with beyond a reasonable doubt in court that they knowingly violated your rights. As it turns out, he writes, that clarification is crucial because in nearly all the other states that have passed similar laws, state courts have incorporated a similar or identical version of the federal qualified immunity. They basically act as subservient agents to the federal court opinion. So if the federal court holds a certain view, then they're going to say, well, we're going to look at everything under the federal constitution based on federal court precedent, and therefore it doesn't work very well. And in fact, it always works in the hands of government. It works to the side of government power. So they have incorporated a similar or identical version of federal qualified immunity, even when the relevant statute says nothing about it. So what they did was they expressly pointed out that this qualified immunity cannot be used as a defense when someone sues them for violation of their rights. Now, some people are going to be very alarmist, like, oh, I would never be a cop in that state because then I can't get away with whatever. Or there's just going to be tons of lawsuits. Well, first of all, tons of lawsuits means the court system gets filled up. And people can have problems if they do frivolous lawsuits. So if everybody just starts suing everybody, that's going to be another problem for the people who are suing. And mind you, the courts, even on a state level, generally don't rule against the government. So this is really no silver bullet to dealing with this. And this isn't going to be a huge change, but I think it's the beginning of something that could grow into something larger. As it says on our membership cards, Concordia res parve crescunt. This is a phrase used by the penman of the Revolution, John Dickinson, in 1767, saying that small things grow great by concord. You oftentimes have to start with one small step when you want to advance liberty. Rally people to the flag, to the cause. Point out that something can be done, and then other people can build on what you have done in your area, in your own goals. Going further, so Mike Maharrey covered this as well. Signed his law. Colorado creates state process to end qualified immunity for police. This was just last month, and he basically covers the same thing that Jay did. But now, because of that, just 3 days after that bill was signed into law, we saw another state, and this is again going back to that small things grow great by concord. Now that they've done this, we've already seen another state with legislation, similar legislation, and I think in some ways Mike told me when he was reviewing the bill before he did the report, I would have asked him this morning, but he's got a few days off and I'm not bugging him this week until he's back to work. But he said the bill in New York State that was just filed 3 days after that law was signed in Colorado is actually stronger in a few ways. I'm not sure why. I haven't read it in full detail, but here an overview of it from Mike's report that we just published. Actually, this morning, the date on it is wrong. That's my bad, but I will fix that. Senator Kevin Parker, this is a Democrat from Brooklyn, he introduced Senate Bill 8618 on June 22nd. The legislation, Mike writes, would create a cause of action in state courts to sue police officers, quote, who under color of law subjects or causes to be subjected, including failing to intervene, any other person to the deprivation of any individual rights that create binding obligations on government actors secured by the Bill of Rights, Article 1 of the state Constitution. We should be focusing most of our energies on everything under state constitutions. They're so forgotten. But the federal constitution has been so manipulated by federal power, federal courts, federal judges, the federal Congress, the federal executive branch. It's almost a lost cause other than using it as an educational tool. You can't You can't just preach the Constitution and then just say it and hope that it'll be followed. So the founders actually wanted us to focus most of our energy on the state constitutions, and that's what James Madison was talking about in Federalist 45 when he famously wrote that the powers delegated to the federal government are few and defined. Those reserved to the states, and the people that is, are numerous and indefinite. So when you have a problem, a violation of rights, it is a state issue. Mike goes on, he says, the law specifically states that governmental immunity, and this is from the legislation, the proposed law, to be detailed or technically correct. Governmental immunity shall not be a defense to liability pursuant to this section, and qualified immunity shall not be a defense to liability pursuant to this section. There's a lot of grassroots support for this legislation, Senate Bill 8618. I'm not sure if the establishment left and right, it's kind of a weird mix in New York State, will allow the legislation to even get a hearing or move forward. But this is just an example. Here we are basically in the off season as far as legislative sessions for states go. But Colorado is the first. We have another piece of legislation introduced in New York. There's another one introduced in Georgia, but when we looked at it, it was really just worded very poorly. So we're not even gonna, maybe we should put out a report on it explaining the problems with it. And there's another one, I think, maybe in Louisiana. But basically, what we need to see in the 2021 legislative sessions, and a lot of states will be filing, legislators in various states will be filing legislation, pre-filing for 2021 January, starting as early as August. In many places, it's in November. So over the next few months, we're going to see this. And I encourage you, whatever state you're in, if you think, like I do, that qualified immunity is atextual, ahistorical, made-up judicial garbage, a violation of the Constitution, there is no power delegated to the federal government to give itself qualified immunity for violating rights just because they're working. I mean, this is just absurdly bad. We're basically dealing with stormtroopers at that point. Then you should contact your state legislators, your state senator, your state representative, and say, hey, look, this bill that went into law in Colorado, this bill that's being proposed in New York State, take a look at it. I'd like to see you introduce something to end qualified immunity on the state level. And it doesn't take a lot of people making that request. Maybe a half dozen people making that request, and we'll start seeing bills introduced, and this could be a huge issue on the state level in 2021 and the years going forward. Now, Ilya Somin covers this a little bit further, and he says, as Schweikert points out, that's the article in Cato that I was just covering, SB 217, and again, he hadn't covered the New York bill yet, but this would also be the same for that, doesn't technically eliminate qualified immunity as a defense to lawsuits charging violations of federal rights. I'm skipping over the constitutional. Everybody has to call it constitutional rights. Federal rights, but it effectively achieves the same goal by eliminating it as an obstacle to lawsuits under the state constitution, which provides much the same rights. It doesn't provide the rights, but it actually, in many places, in many states, the state Bill of Rights is actually stricter, stronger than the federal Bill of Rights. If you read it closely, some of them are. So you're basically focusing on an area where you can get more protection. And when there's a bad opinion from a court, it doesn't affect everybody. So if someone sues a government official in Colorado for violating their rights, and the courts are just terrible there, which I assume they are, but let's just say they have a terrible opinion and they say, well, no, now we need to follow this process. At least the bad effects of it only affect the people in Colorado. It doesn't spill over to California or Oklahoma, Nebraska, Texas, Florida, and elsewhere. And that's what happens when you sue in federal court for a local violation of your liberty. So he thinks this is a really good way to eliminate an obstacle. So then when people have their rights violated, which happen all the time, they can sue in the state court. It doesn't even become a federal issue. The feds might want to try to claim that it is a federal issue, or the defense would probably do that. So it doesn't even have to come up. They're going to probably try this. And that's where Ilya points out that there are limitations to these types of laws, because they can still end up in federal court. And when you end up in federal court, you're just done for. That's my view. And that's what he says. There are nonetheless a few limitations. It may not apply to state federal task forces. And I've covered task forces in some detail in the last couple of months. And he says this is where state and local cops working with the feds can claim immunity to lawsuits under state law on the theory that they're really acting as federal agents rather than state ones. And Meharry did an article on joint task forces titled "Joint Law Enforcement Task Forces Are Creating a National Police State." This was in April of this year. I will link to this in the show notes at 10thamendmentcenter.com/path-to-liberty so you can read it in detail. But basically what happens, and there's hundreds of law enforcement task forces. There's gun task forces, there's forfeiture, there's drug war task forces, there's all kinds of stuff. They claim everything as terrorism, so there's anti-terrorism task forces. So basically what you get is various state and local law enforcement agents, sheriff's departments, local PDs, plus a federal agency, maybe the FBI or the DEA or the ATF, most of which of these things shouldn't even exist, and then it becomes a federal issue. And what happens is it creates this kind of jurisdictional neverland. That's how Meharry put it in his article back in April. He says this allows members of these task forces to escape accountability or punishment when they use excessive force, destroy property, or simply engage in sloppy police work because they can claim, well, we're on this federal task force, so technically we're deputized as federal agents. So if you want to sue us, you're going to have to sue us under the federal courts, in the federal courts, and therefore you're done for. There's no way to win these things. The federal courts, the Supreme Court won't even take it up. They won't even hear it at this point. So at best, you've got a few years of waiting and going through maybe a year if you're lucky. But the fact that they just rejected a bunch of cases, considering a bunch of cases just last month, the odds of them taking any up next year, I think are slim to none. At best, suing in federal court is going to be the next chance to even get this heard is a few years out. In practice, Mike writes, joint task forces can pick whichever laws, state or federal, afford them the most power and the least accountability. And in general, they pick federal. They always claim when there's a restriction on their action under state law, they participate in a federal joint task force, and then they say, well, this is federal law, we're federal agents, and we're no longer working for the state. The state constitution doesn't even apply. We are under the federal constitution. So that is a huge problem. And I covered this partly as one of the main ways that the federal government militarizes and nationalizes local police. They do this through grant programs. There's 3 federal grant programs that hand out either equipment, from military equipment, armaments, to also surveillance tools. They hand out all kinds of surveillance to just cash grants to do whatever. Of course, it's always to fight drugs, guns, terrorism. They all kind of tie together, and really what they're saying is we're the terrorists, we're the bad guys. Liberty, it's a war on liberty, and that's how we titled this article. But the other main problem is absolutely these joint task forces, because even when you see local law enforcement activity in your city, especially in larger ones like where I live here in Los Angeles, a lot of times, for all you know, even if it says LAPD, they're really FBI or DEA or something like that, or ATF. And there is no state law or restriction that affects them, or at least that's the way they approach that. So you can do something about that too. It's not like we're playing whack-a-mole. First of all, you absolutely want to end the use of qualified immunity in state courts. But then you also have to start the process, thinking about the process of withdrawing from these federal joint task forces. Most federal laws, rules, regulations, acts, treaties, orders, all this, most federal stuff on the books today. And I think we can be safe in saying half of it, 60, 90% of what the feds do shouldn't exist under the Constitution as given to us by the founders and the ratifiers, the people of the several states who gave it legal force. Most of it shouldn't exist. So when your local law enforcement is participating in federal task forces to get federal grant money, they're enforcing unconstitutional federal acts. So therefore, the localities should stop participating in them. We saw San Francisco do that in some ways recently with an FBI anti-terrorism task force. There's also a piece of legislation here pending in the California legislature that I don't think is going to go anywhere. AB 2598 from Rob Bonta. This is the California Safe Civil Rights Act. It would require a California law enforcement agency that participates in an FBI Joint Terrorism Task Force to do so only in a manner that is fully consistent with the laws of the state of California, including the agency's own policies, procedures, and orders. So in other words, if you, right now, the way it plays out, if you were to withdraw from qualified immunity or end qualified immunity as a defense under state law, then the local law enforcement would just, if they were concerned about this, would participate in a federal joint task force. They do this with civil asset forfeiture regularly. When they're restricted on conducting civil asset forfeiture on a state level, what they do is they call up the FBI or the DEA and they say, well, this is a federal issue. And it becomes a federal case with one case officer, maybe two people in DC or whatever regional office. The local law enforcement still does all the legwork. They still steal stuff. But because it's a federal case, the feds take all the money and then they divvy it out. 80% go to the local law enforcement. The feds keep 20 for doing nothing beyond basically taking a call, or because they're government and they're archaic, they probably are getting faxes or something like that too. So the same thing happens with these types of joint task forces and trying to deal with qualified immunity. You end it and they're just going to say, well, I would assume. I'm very cynical on the way government works, so I would expect them to do the same thing that they've done with asset forfeiture. Restrict them on a state level, they'll just call everything a federal issue, participate in more federal task forces. So the way to do that is legislation similar, probably much broader than this. This is very narrow, but similar to the California bill that's pending, AB 2598, that if you're going to participate, it's not saying we're totally out of it, we're just withdrawing. I would say withdraw, because so many federal acts are unconstitutional and shouldn't be enforced in the first place. But a good kind of step forward is to say, look, if you're going to participate in these things and we restrict your action on a state level, you cannot do an end run around that and just say you're federal agents. Although how that plays out in court is kind of another thing. But then what the legislation does, it has basically a trigger. It says if you are doing that, you're not allowed to participate. If you are acting in ways that would be illegal under the state constitution or state laws or policies and procedures as a local or state agent, you're not allowed to be a federal agent. You're getting paid to be a state agent. Why are you spending all people's money acting for the feds? And most of the time, the feds are having you do stuff that shouldn't be done in the first place. So that's another piece of the puzzle. And Ilya Somin over at Volok, he points out again this issue, another issue. He says, another issue here is that where the government enables state and local law enforcement to get around laws restricting asset forfeiture by having the federal government adopt state seizures and then in effect share the loot with the state and local friends. So again, the real issues about the ending qualified immunity legislation in New York State and the new law in Colorado are really the fact, it's not really in the legislation itself, it's just that the local agents are acting as a national police force. So they need to opt out or restrict participation in these federal joint task forces, and they also need to deal with the federal drug war, federal gun control, but also, as he points out, this asset forfeiture situation. So you can opt out of that as well. And it was very nice of him. He actually linked to a report that we did about a law in Colorado that does opt the state out of about 85% of situations dealing with the federal equitable sharing asset forfeiture program. And he puts it this way: fortunately, a 2017 Colorado law already imposes tight limits on state and local police participation in the federal equitable sharing program that facilitates adoption. But Colorado should take this reform even further and forbid such adoption altogether. And I've often said in these situations, I will take an 80 to an 85% improvement. And at this point, I would take a 5% improvement as long as it isn't promised that 5% is all we need to do. So we're at about 80 to 85% in Colorado on ending federal equitable sharing in the state. And Ilya is absolutely correct. You need to get it to 100% because they're going to really, if you don't shut it down, that door is still open and they're going to keep pushing to open it further and further and further. But he sums it up like this, and I agree. He says, despite these limitations, SB 217, and I would say the same for the New York legislation, which is Senate Bill 8618, it's an impressive step in the right direction, one that other jurisdictions can learn from. Other states might also be able to learn from the process by which Democratic Governor Jared Polis and legislative leaders quickly secured broad bipartisan support for the bill. I think it passed with only a handful of no votes, both in the state Senate and the House of Representatives. And if you understand the Colorado legislature, it is very partisan and very much divided there, especially on the Senate side. So the fact that there was very few no votes is actually pretty huge on an issue like this. He says, as always, the best should not be the enemy of the good, and this law is very good indeed. And I wouldn't even say that one particular law needs to deal with 10 different things. In fact, I always make the case that the more that you try to deal with in one single law, the more excuses you're going to have from the opposition to be like, well, we need to review this, and it's going to slow the process down and give them an excuse to not pass it. But if you take on one narrow thing in one bill, like dealing with qualified immunity, that doesn't solve all the problems with government, but it certainly creates an opening for people to use the government courts against them. And again, I'm not a big fan of that strategy, but at least changing the status quo where everything is a federal issue and the feds are so awful. But then you also have to deal with joint task forces, the drug war, gun control, civil asset forfeiture, and probably a lot more. Well, I hope you guys found this interesting. I hope it was educational. Most importantly, I hope it's something that you learn. That's more important. I'm learning as I go on this too. I would say a month ago, if you asked me like, hey, Bolden, how are we going to deal with qualified immunity on the state level? This wouldn't even have crossed my mind. So I'm excited to be learning about this, but because of the work that I do, it's very natural for me to just dive in and be like, oh yeah, this makes total sense. I'm embarrassed that I didn't think of it right off the bat. I should have been the first one on this, but I don't care. I'm glad that it's happening, and I would like to see the grassroots support this type of thing across the political spectrum, and instead of fighting with each other, can find some common ground and say, let's set aside our differences on whatever social cause and focus our energies on trying to stop the government from doing this to us, because government has been doing this to all of us, whatever our background, for a long, long time. I'm going to check the live chat and the comments a little bit later. I have a maintenance issue, a little plumbing leak here in the apartment. New place, but well, we'll see how that gets resolved. Hopefully I'll get that fixed in the next couple of hours. So I'm going to go back and check out the comments a little bit later. I appreciate you leaving your feedback, questions. I see a bunch of interesting stuff out here as well. So I will check that. If you have any other ideas, thoughts, feedback, you can also email me, team@10thamendmentcenter.com. If you enjoyed this information, make sure to smash that like button. Hit subscribe on places like YouTube and elsewhere. On iTunes, reviews, that helps a lot. Basically, all of these actions that are free and take a minute or seconds to just seconds out of your life, all of those things trigger the algorithm of the platform you happen to watch or listen on, and it tells that platform to show the program to more people. So that helps a lot. And of course, if you really want to get in on us and support what we're doing financially, you can join our membership program for as little as $2 a month. We also have annual, 5-year, and lifetime memberships where you get one of these cool little membership cards as well. We personalize them with your name and a membership number. That's all over at 10thamendmentcenter.com/members. I will point out one comment that I see here from Eric Roth over on Facebook. He says, it may be narrow, but it's a start. It gives you the ability to cite it for future expansion. Absolutely. And that's the whole point of what's on this card, what Dickinson wrote about, what we talk about every day in our strategy. You start with something, you don't cite it as the end game, and then you build on that. The ground of liberty, Thomas Jefferson wrote to the Reverend Charles Clay in 1790, the ground of liberty is to be gained by inches, because sometimes, and I'm paraphrasing, it takes years, it takes a long time to convince people of what might be best for them. Anyways, I hope you enjoyed the episode. I hope you learned something. I hope you get on board in support of getting this type of thing done in your own state or even in your local community. I appreciate you being here, and I'll see you next time here on the Path to Liberty.